I hope you are having a good night so far. I wanted to hop on really quickly and just read and go over some of the context in this post conviction petition written by Brian Kohberger. And this news coming out just today. I've been reading over it over and over again for the past several hours, just kind of dissecting everything. And I thought that we could just kind of quickly break it down and just kind of go line by line, just to kind of see what he's not saying and what he is saying in this, and just to kind of analyze. So, starting with this first section here, you can tell right away when he says it is hereby declared that, during these attorney-client discussions, that he was convinced to falsely confess. So this right here, this entire statement is not casual. This is a sworn legal document. So essentially what he's doing is he's trying to lay the groundwork to say that he probably had ineffective counsel, I would guess. He's not just saying, hey, I'm innocent, I didn't do this, but he's pleading with the court, essentially saying that this conviction it's legally invalid, right? Legally, we cannot go through with this because it was based on lies. He's put himself under oath. So essentially this document is like appearing in front of a judge and, putting your hand up and swearing to affirm and, everything is going to be true. He's doing that. And this is confusing to some people because, well, he swore on oath that he was guilty when he took the plea agreement. So there's definitely a contradiction, right? Because if he was telling the truth then and he's telling the truth now, but basically what he's saying is he was not confessing based on guilt in that initial plea agreement. He was admitting and agreeing to take that plea because of what his counsel told him. And that's where the coercion comes in, because he was using specific language, right? So that's what we're looking at here. The language that he used: convinced, forced. He was convinced to falsely confess. So someone else convinced him to say that he was guilty. He doesn't come out and say, I was threatened or I was physically coerced. It just implicates the people around him in psychologically manipulating him. And he in turn, again, uses those kind of psychological framing words. That coercion right here. So he was coerced into telling them that he's guilty. And basically by building that narrative here, this isn't claiming that he was in any way mistreated or anything, but he is building a narrative that he was forced into this under coercion. And he specifically states disinformation. And that again points to, I would say, not having counsel that was effective. So ineffective counsel. Disinformation. Very interesting, right? And so false promises here. He's hoping that this will invalidate that plea. So this is written very clearly, intentionally. It's not emotional. It's not someone saying, I'm not guilty, I didn't do this. This is him listing out bullet points. 1, 2, 3. I mean, he's got them. Another thing I find really interesting is this part, the withholding of exculpatory discovery. I think this here is the strongest argument right here. He's alleging a Brady violation or a failure to disclose exculpatory evidence. And then this is the one example, and it's interesting that this is the example that he specifically chose. The hair found in Ethan Chapin's hand. That is a concrete piece of evidence that he names. He's able to list this one piece of evidence. And now he can compare that to what was reported to him pre-trial. And he's claiming that this exculpatory, that means that this evidence, exculpatory evidence, can directly support his innocence. And this is a huge piece of evidence. The prosecution evidence included the DNA on the sheath, and that's what they had to link him physically to that scene. But until this day, we don't have the murder weapon. We don't have any clothes tying him to the scene. He's left no other DNA at the scene, and he's brought no victim DNA with him in his vehicle or in either of his homes. Not in his Washington residence, not in his parents' Pennsylvania home. So, he's highlighting this, and this is such an ambiguous piece of evidence. And he's completely ignoring the other evidence that was brought forth. Right? So he's specifically naming this as the first thing that is the issue. He's basically saying that ineffective counsel, right? His lawyers didn't investigate this enough, and he only found out after the fact. He doesn't list what inquiry, if made, would have shown. He doesn't hypothesize. He doesn't go into that. So number one, exculpatory evidence. Number one, he's basically saying that he didn't know everything, because that's the crazy thing, is if you're expecting someone to agree to a plea deal and say, I am guilty of committing this atrocious crime, the plea must be knowing and voluntary, but he also, as the defendant, had a right to know every piece of evidence, and that was never told to him. We, the public, only found out through that recent document drop, so no one told him about the hair. What else didn't they tell him about? Did Ann Taylor know? There's so many questions, but he's basically saying, I didn't know everything about my own case. And if I didn't know everything, how could I have possibly made this plea? So he is trying to undo that sworn plea because there was information missing in that agreement. He also goes on, number 2 here, to state that actual guilt was not an important factor. This is really interesting because he's essentially telling the court that whether you're guilty or innocent, that doesn't matter, which it does. Courts require defendants to, again, have all of the information. And when you're under oath and you affirm that guilty plea, you're swearing that. But I think it's really interesting that his counsel would say it doesn't matter. That it doesn't matter if he's guilty or innocent. It's just, this is like, just let's do the deal to get you out of death row. Which leads us to point 3, that death row was imminent and he was advised to lie for a legal victory. But if we really look at that, I mean, in a court of law, we're talking a court of law. When you go into the court, even if it's for a traffic ticket, you have to swear that you're going to tell the truth. So if he's alleging that counsel advised him to lie, that is a serious accusation. And also, legal victory. For counsel to tell him that that would be a legal victory, that would be framing the plea as strategic and a move rather than like a factual outcome. So he's basically telling us that this whole plea agreement was a tactical move, basically to keep him alive and off of death row, rather than an actual admission under oath of his guilt. So it's just really, really interesting. Now, he states here a gross misrepresentation of a life sentence versus death row. He's saying that he was misled. So the life sentence conditions versus the death row conditions were apparently explained to him by counsel. And listen, this is interesting because who was telling him this? So he's basically saying that they were telling him a fabricated story and that it would be a horrific experience and that his counsel directly toward a 6x8 or 8x8 death row cell. And this is very specific because this is not a general view that he had or a general statement. He's claiming that they specifically told him about the conditions. And that means that he was persuaded and emotionally manipulated. Now, again, this is all uncorroborated. We don't know what his counsel actually told him. We don't know. We were not in those closed meetings. Only Brian Kohberger, his family, and his counsel were present. But, that's a big statement. So this basically also kind of ties in his family because he did note in the very beginning that his family was present. So again, we're taking emotion into this, and if you've ever had a family member or yourself been involved in the justice system, it's overwhelming. And if you have an attorney who's telling you, if you go to trial and you are found guilty, to accept that you may be put on death row, and during sentencing, if that is the outcome, this is the way that it's going to be. This is how you're going to be living. And apparently the conditions were told to him and his family, and they were essentially threats, because he does use this here, constituting threats and promises made to induce a plea agreement. So again, it all goes back to the plea was not voluntary. He signs, "I certify under penalty of perjury." Like, he's already done this with the plea, but this is his legal right to now say that he was lied to. So the language here that he uses is very, very legal. It's strategic. He is essentially explaining that there was fear and coercion and all of that, but he is not inherently emotional. It's very legally phrased and very carefully structured and worded. It's clear that he took time to really write this with intention, and he focused on that one piece of evidence. He didn't go into a lot of different evidence or DNA or vehicle issues or any of that. He specifically listed one piece of evidence that was never told to him. So he's basically separating the truth of the actual plea and the situation surrounding it with what was said in the plea. He definitely builds a narrative here. So I think that that's really important, and I just wanted to quickly take a look at that. All right, I think that's going to do it for today. This is a lot of information coming out today. Some people are really excited, some people aren't. It just depends on what side of this case you fall on, but I think this is going to be pretty big news with this case. I do plan on making more content moving forward, and what I plan to do is cover everything from the beginning of this case moving through. So if you are new to the case, or if you are just a casual viewer of this information from time to time, or if you are a veteran and know everything about this case since day one, feel free to join me. I'm going to just be looking at everything with a fresh set of eyes, because I was looking at some of the original information that came out in the early parts of this crime in the November, December of 2022. And there was so much information coming out, and I appreciate all of the true crime commentary channels that were breaking all of the news, but I believe that it's a little bit overwhelming to try to go back and watch other videos sometimes. So for my own sake, this is kind of my pet project, that I'm going to retrace all of the steps of the investigation with whatever materials I have available to myself from, the public archives, as well as anything posted on YouTube. So if you are interested in taking that journey with me, I will be here. I plan to make videos every week, if not every day. So with that being said, thank you so much for stopping by, and I will see you in the next one. I hope you have a great night.